Welcome back to the channel. My name's Ken Johnson. So today I thought we would talk about my profession as a mediator. What is mediation? What you would expect to see in a mediation, etc. So before I get started, I wanted to state that I did this namely as a response to so many people asking me about mediations through the channel. They're fans of the channel on other social media pages or even in person when I interact with them. So it is not necessarily a training program. It has not been approved by any bar association or any credentialing authority. However, if your credentialing authority allows online education, this may be used. You'd need to go to that source for guidance on whether or not they will accept it or not. But should you feel so inclined, that is something to investigate. But I am not doing this video for continuing education credits for your bar exam, or not bar exam, but your bar certification for lawyers, for mediators, they're also lawyers, or your mediation credits that are required. Please check your state and local authorities as to guidance on what you need to do. What is a mediation? Well, that can look a number of different ways, and it can happen a number of different ways. And we'll talk about the different types of mediations and how they'll look in the future. But simply put, it is a confidential, facilitated negotiation process. You usually have two sides that are opposed to each other due to a conflict, and then you have a third party, somebody like myself, who is trained and certified in the art of mediation. And they are supposed to be a neutral, impartial third party that helps you to reach an agreement, if at all possible. Are there more than one type of mediation style out there? Well, yes, there is more than one type. In fact, there's multiple types. There's four that get a lot of the discussion, but there's even more than that. The first one is the most common, and it is what I am trained in. It is what the state of Florida requires. It is really what a lot of states are gravitating towards, and that is facilitative. So excuse me. So a facilitative mediation is where you have a neutral, impartial third party that is trained and certified in the arts of mediation, and they help facilitate an agreement between two parties. The mediator has no authority whatsoever to making decisions or to come to any conclusions. I have to treat all parties equally. Even if I am skilled and trained and have legal certifications in other fields, I cannot speak as to the law, and I am really restrained into what I can say. In fact, in most cases, the training that I'm given says that instead of me saying what I think people should think or believe, I have to pose it into a question to have them come to their own conclusions. And so I will have somebody that I'm wanting to test out their belief in reality, what we call reality checking. So one of the things I might do, and I have done several times in the past, is what do you think a judge will say about this, whatever this is, that XYZ variable? And I let them come to their own conclusions. And so by having the person answer questions and think for themselves, it redirects their line of thinking without me making any decisions for them. They're coming to their own conclusions. So the next one is evaluative. So evaluative mediation is really rare. You do see it in the United States. It's normally done in higher end negotiations, or where a negotiation isn't considered to be a strength. So the idea is equitable distribution of assets. And so, what is fair? What is legal? What would a judge do? And so, in this case, you have somebody, usually a lawyer, that is exceptionally skilled in a certain area. So you're not just getting any lawyer, you get one that is an expert in that field. And so you go to this lawyer that is also trained in this style of mediation, and they will have you present your stuff, your sides and everything, and then they will do evaluations on the strengths and weaknesses of your argument. And then in some cases, they may even state what they think a judge would render as a verdict if it goes to court. A lot of attorneys like doing evaluative mediations because you have somebody that they respect as an expert that is another lawyer, which gives them comfort because they know the law. It's not just a plumber or electrician saying what plumbers or electricians should or shouldn't do, but it's actually a lawyer. So they might be a lawyer dealing just in plumbing, and that's all they do. So you not only have somebody, this is somebody that's been to court, seen judgments, worked with the judges in something very specialized. And so they like to use this because they can then know the merits of their case and also the merits of the opposing party's case and get a better idea of where they stand. And again, this is not something that Florida allows in court cases. You're free naturally to find somebody, but you normally will not find these types of mediators in states where facilitative mediations are mandatory. So you might find it in another state, but normally not in states like Florida, but you could find them. And also, it's exceedingly rare to find somebody because you not only have to have somebody that is an expert and a lawyer, but also trained in this type of mediation. And so that makes it exceedingly difficult because it's not a one size fits all like facilitative. The next type is called transformative mediation. Transformative, and the next one following, it kind of blurs the boundary between two different schools of thought on alternative dispute resolution, or ADR. ADR is what mediation is considered. It is not going to court. It is not the standard. It is something that is an alternative to normal dispute resolutions. And if you consider on a spectrum, you have, mediation on one side, and then you have something called restorative justice or restorative practices. Now, I'm trained in both fields. So I received my restorative justice training from the University of West Florida College of Professional Studies. And so I trained at UWF. I also went to Home and Prison, where they had a restorative justice program at Home and Prison in Atmore, Alabama. Or actually, it's Porch, Alabama, but Atmore. And so I did go into that maximum security death house and deal with live prisoners, and I'm trained in that. I've had 2 books that are multi-award-winning books on how to do restorative practices in the school system because I used to be involved in the school system. And also I was involved in the court system for 20 plus years. But transformative mediation is unique in that it looks at the relationship more than just trying to find out equitable distribution of an asset. So it's typically used in workplace conflicts, community conflicts, things of that nature, where the relationship is more important than the actual conflict itself or what's being disputed over. And so the problem with transformative mediation, for it to be done right and for it to be best done, it takes multiple types of sessions to break down what's going on and work out those issues. And it can be very lengthy and very costly. For this reason, most transformative mediation that you see in America is done in the workplace, and it's very truncated. It's very edited. So they may only allow 1 or 2 hours max to resolve this conflict and everybody be all kumbaya, which is really not a viable ask of a mediator to do when your goal is to improve the relationship through mediation. You've got to develop a rapport, and that takes time, and you've got to see parties or get the parties to see each other as people when there may be years of demonization going on. And that's very hard to do in just an hour or 2 hours. You mostly see transformative mediation done in the United States Postal Service. They have a program called Redress, and a lot of mediators work for the post office as private contractors doing redress. I don't work for the post office. My certification is not with them. However, it's been my experience as a restorative justice practitioner and restorative justice facilitator that these truncated, edited, abbreviated mediation sessions that these workplaces instill do not work as effectively as if you went with a restorative justice facilitator, restorative practices facilitator. The reason why they don't is because of money. And it's very costly because it means multiple, caucuses, multiple meetings. Now, the next one that we'll talk about is in the same vein as transformative. It also blurs that line between mediation and restorative justice, restorative practices. And so it's called narrative. Narrative is a type of mediation where you tell stories. And it's not made up stories. You're telling your story. You're telling your story, especially about victimization. It's sometimes called victim offender mediation, or VOMA. That's another style in America of narrative mediation. It really blurs the lines between restorative justice, restorative practices, and true mediation. And for this reason, a lot of places that use it are places where restorative justice is either mandated or legislated or used intensively. So you'll see it in Europe, you'll see it in Africa, you'll see it in New Zealand, you'll see it some places in Canada, some places in Australia, even in America in a few small locations, especially around Pennsylvania, where the Mennonites are pretty strong, or up into the northwestern part of America where you have indigenous tribes that they are taking a restorative justice approach. You may see it also in some parts of California, but it's only going to be in 1 or 2 cities, nothing big. Again, like transformative mediation, I wouldn't be looking for somebody that is a narrative mediator. If you're wanting to do something along the lines of restorative justice, restorative practices, consult and hire somebody that's trained in that. So if you're interested, I am for hire. That is something that you can do. There are differences between the mediators working in this field and the facilitators. One of the greatest differences is that the mediator is supposed to be impartial, but in restorative justice and restorative practices, we don't have to be impartial. And also, there's more legwork that a restorative justice practitioner or restorative practices practitioner, we will do more legwork than a mediator, so that when we come to the session, to the meeting, we can ask questions that are very thought-provoking because we already know the answers. So for that reason, I think it's better to just hire somebody trained in restorative justice or trained in restorative practices. The two are interchangeable. Restorative justice means that crime or offense has happened, and so you're looking at it from after it has happened and trying to bring everybody back. Restorative practices is where you're trying to prevent issues from happening before it ever goes to court, before offense ever happens. But it's the same thing. The two are interchangeable. There are other types of mediation out there, and I highly recommend that you look them up because a lot of them have merit, but they don't have backing. Two in particular that I'm very interested in, and I wish that more cases or more states would allow it. One is criminal mediation. Criminal mediation can really help in a lot of ways. It's sometimes called felony mediation. There's also misdemeanor mediation, but really it's all lumped up under criminal mediation. I think it would be a tremendous benefit to the court system. However, trying to get lawyers and judges to see the benefit of it can be difficult at times. So it would need to be through a community action group to show the merits and get the community to rally behind them. This would really be a community action approach, not a traditional approach of getting mediation into a system. The other one, really, it would actually impact me financially to my detriment, but I think it's a good idea. It's called collaborative law, and it really is good in the field of family law, because what happens with family law as a mediator, I'm given so many hours, in the First Judicial Circuit, it's 3 hours, that I'm supposed to resolve all the conflicts of that divorce or paternity case. And then from there, they're supposed to go on and do their thing. And eventually a judge signs off on it. Collaborative law has a element to it where you've actually got an attorney that is the mediator. So they are trained in family law and they do divorces and everything exclusively. And they've done it for so long that they are now seen as an expert. And so should the parties not come to agreement, there is a element in there where the mediator can act as a quasi arbitrator. Arbitrator is kind of like a pseudo judge. And you have binding and non-binding. And I don't want to get too technical, but you would have it either binding or non-binding, depending upon how the state's laws are set up, where on issues that they never did reach an agreement to, that the mediator can decide. based off of the decisions made. And I think that there is a good niche for that in family law, because right now, the way it's set up, I get 3 hours. I tell the parties, have one or two issues and try to work with each other on getting all the other stuff resolved, and just have one or two issues that you come to me with, because we only have 3 hours. And I know that 3 hours is not enough for me to unravel everything that's been wrong with our relationship. And these people, they fight so much that most of the time I may spend an hour and a half, 2 hours just getting the parties to act like decent, normal human beings to each other, because they're so angry with each other. And that gives me maybe 30 minutes or less to work out the issues, get some type of agreement going, and then start writing out the contract, getting them to sign it, explaining what the elements of the contract would look like, all that. So I really think that that's another field. So there's a lot of other fields of mediation out there. But like with any type of rules, regulations, practices, etc., you have to get the rule makers to see value in it. And a lot of times people are either going to lose money, and so they don't see value in it because they're going to lose money, or they just say we already have something that works and they don't see a need. So some of this is going to be require the community to act. And unfortunately, at least in America, the communities normally do not bring anything forth to lawmakers, because most people do not vote in America. We have exceptionally low voter turnouts. And so you don't really see too much community activism on an issue. And since most Americans don't even know what mediation is, I highly suspect these will just be for textbooks or training materials for other mediators and lawyers, and never be put into serious application unless something is done to change that from the community. What can you expect in a mediation? Well, it's been said that there can be up to 6 stages of a mediation. Now, you don't have to have 6, but there can be as much as 6. And in the court system, we have a Latin term, sum sic, and it means on a case-by-case basis. So the mediator oftentimes, unless mandated otherwise, will choose how to proceed based off of how the people are reacting or information received about their previous relationship. Very rarely do you have a case where the law says you must do this or you must do that. For instance, in Hawaii, I do a lot of mediations online for Hawaii eviction cases. And I have contracts with 3 of the 5 mediation centers that deal with landlord-tenant evictions. Almost all have what they call the diamond method. But they have also said, because of the way that I mediate in Florida and my success rate, even though I hate that term because there's really not a such thing as a success rate with mediations, but because of the way that I get my mediations handled and the way that everybody seems so favorable to it, that I'm given special permission to waiver from the diamond method if I so choose. I'll talk about the diamond method in a minute, but let me talk about the methods themselves, or the stages. The first is mandated by law. So it is the exception. It is not the only exception, but it is one of the 2 exceptions. The last stage is also mandated, and I'll get to that too. So the first stage is opening statements by the mediator. So why do you need an opening statement by the mediator? Well, it kind of lets everybody understand what's going to happen, why you're there, what's expected of you, what can be said, what can't be said, that kind of thing. So I'll give you a quick down and dirty opening statement that I generally do for most of my cases. So it goes something like this. Thank you for coming today to the mediation. My name is Ken Johnson. I am the mediator that's been assigned to this case by insert agency. So what is a mediation? What is my role in all this? Simply put, a mediation is a confidential, facilitated negotiation process. My role in all this is to help you reach an agreement if at all possible. Everything that we say and do in this mediation is confidential except where I'm required or permitted by law to report. And then I'll continue on. I'll talk about my customs. Every mediator has a certain way that they like to handle things, and so that lets them know it's your custom. It's not required, but you like to do it that way. And one of my customs is I like to keep things informal. I tell people that they can have a drink, and so that's a bad video thing of the drink, but I'll tell them, please have a drink if you want to have a drink, because we're using Zoom. And that's allowed. And I tell them, can I use your first name? So these are customs. They can say, no, I won't be referred to as doctor such and such, or I won't be referred to as attorney such and such, and that, counselor or whatever. But it at least kind of sets the tone, sets the mood, and lets them know. But what is that part about required or permitted by law to report? That's pretty critical. And most people don't even pay attention to it. Over the years, Florida law has changed tremendously. At one point in time, I was only required or permitted to report child abuse and nothing else. And so over the years, restrictions have eased to the point now that if I am told of a crime that has not been reported to the authorities, I now can break confidentiality. And that's critically important because I'm held to a standard of confidentiality that a judge has. So I don't have the type of confidentiality that your lawyer, your priest, your doctor, your social worker, or your therapist has. I have judicial confidentiality. That means that even if a judge asks me what went on in mediation, I have to do everything I can to stop from testifying. And that means I might even have to file motions and cite the law where you cannot require me to testify as to what took place. That's pretty strong confidentiality there. And giving me that authority that I can now talk about somebody that might have developmental issues being neglected or abused, that protects people, that keeps people safe. It's critically needed. Child abuse, elder abuse, somebody's about to be murdered. Beforehand, somebody said, when I first got started, they said, I'm going to murder this person tonight. And I'm just telling you, I couldn't do anything under the law. I would actually go to prison if I said something. Naturally, I would have gone to prison because a life is too important for me versus my job. I would never, it's unconscionable to me to allow somebody to die. But that's how absurd the laws were. Now I have that ability. So that's important for you to realize that you can say something, and even though it's confidential, if it's not been reported to the law, that mediator may have to report it or may want to report it if allowed. So you need to be aware of that. Then the second phase, the parties have a chance to speak. So what happens here? Simply put, one side will start, and the mediator may decide, or they may decide. Normally, mediator decides. And so usually is the one bringing the case to whatever authority has set up the mediation. So if it's courts, it'll be courts. I do contract work for the Department of Financial Services. And so what I do is I actually have the policyholder speak first all the time, because I tell them that's my custom. And other mediators, it's whoever brought it to the Department of Financial Services. And so I've had some people say, wait a minute, I was expecting to speak because other mediators. I'm going, well, unless they just really don't want to speak right now, this is my custom and that's what I go with. And it really we never have any problems. Most people use the mediator to take the lead on what's best. And it really works out for me a lot of times. The third phase, and let me go back. I want to go back to the second phase. So what is being said there? Well, you can pretty much say wherever you want. You can say, kiss my butt, whatever. I mean, I would ask that you be nice. And I would probably say something about being nice if you said something about kiss my butt. But really and truly, you can say whatever you wish. But I try to tell everybody, be nice, be polite, treat somebody like you want to be treated. Remember a golden rule. But the whole purpose is so that we know why you're there, the facts surrounding the case, what you're looking to see happen, what you're expecting, what you're offering, what you're willing to consider. Those types of critically important information that you would want to share with the other party, and also that you think the mediator needs to know. And so mediators will differ as to how much information that they want to get. When I go into mediation, I have virtually no information about the case. And if information is given to me, I rarely look at it, because I'm supposed to be impartial. So I do not want to read anything that might color my perceptions of one party versus another. And so a lot of times I will go into mediation and they're like, oh, we got you. So we know we got to have the facts, because you want to know dollar figures. You want to know what the monthly bills are. You want to know this information, because you're going to come back later and use that. And other mediators, they focus on other things, and every mediator has their own style. So I would recommend that if you ever are in mediation, don't try to offer up what you think the mediator wants to hear, but what you think the other party needs to hear so that they can reach an agreement with you. For instance, if you're willing to go in with a price lower than your original ask, it might be a good idea. Let's say it's a $100,000 claim, and you say, hey, look, I'm willing to, if you're wishing to negotiate with me today and you're going to be honest and genuine, instead of the $100,000 I'm asking, I'll take $93,000 right now. And that's what I'll start out negotiating. So I'm already giving you a $7,000 discount in good faith effort to reach a decision today. That's pretty powerful information to share. That lets them know, okay, they're coming down, they're willing to negotiate. Then I might want to work with them, with the understanding that if there is no settlement agreement made at mediation, the offer goes away and it may be gone forever. So that's good information to have. So the third stage is where we get into some murky stuff. The third phase is a joint negotiation process. Now, remember I said the diamonds process that they have in Hawaii? Well, the diamond process, they totally get rid of this. In Florida, we sometimes call the diamond process the circuit model. I don't like to use the circuit model unless I need to. And I don't like to use the diamond model unless I have to. I like for the parties to be face-to-face talking to each other so long as they're civil. If everybody is civil and everybody is working towards agreement, then I see no need for us to break out into separate meetings. So this is where you can jointly discuss. You can say, okay, I hear that you said that you would take $97,000. Our ask today, we're willing to pay you $50,000 because we see these problems X, Y, Z. And sometimes I may share the screen. I allow them to take over the Zoom so that they share a photo and say, hey, look, these shingles here, if you look at the cracking, everything, that's not wind, that's wear. If you look at this is rot, this is not wind. But we do realize there was a wind event, and these areas here, that's not rot, that's not wind. So we're going to say 50,000. And then the other party, they may say, can I share the screen? And they go back and forth until finally maybe it's a settlement agreement of $75,000. Okay. That's the whole purpose why I like to have everybody in joint session. However, you don't have to do that. And sometimes you, especially in family law cases or even in eviction cases, you see it, and definitely in circuit cases, you see this a lot. You get to a part where there is some agreement, and then it's like, we need to break out. And so that's when we go to our fourth phase. Our fourth phase is what we call caucuses. What is a caucus? Simply put, a caucus is nothing more than a private meeting between the mediator and one party. So remember, you got two parties and the mediator, or two sides in the mediator. So thanks to Zoom, I can put people into different rooms. And so I will take, let's say defendant and plaintiff. All right. So we got a defendant that I'll meet with, and we'll talk a little bit in private. I cannot share anything that we say unless that defendant allows me to share information. They may say you can share everything, or they may say only tell them this. And I have to abide by that. And then I'll go over to the plaintiff. And the plaintiff says, well, what does the defense say? And I'll say, well, I can't say, or I might hold back willingly because I want to see what they have to say. And I'll say, well, before I do that, why don't you tell me what you're thinking? And then I'll kind of share where they're at. Because sometimes I might be able to get some information later to reach out an agreement. So I'm always gathering information that I can use towards reaching agreement. But the idea is that I can go as a referee between the parties in different rooms until we reach a agreement. Then the fifth stage, which may or may not happen, is what we call a joint caucus or joint session. So everybody comes back together and we say, okay, now it's time. I think we got an agreement forming. Why don't I bring up the contract? So I have, we're on Zoom, so I have my computer system handy. If I was in a in-person meeting, that's when I would break out a notepad and write it down, or break out my laptop and start typing up a contract. How do you want this section to read? And how do you want this section to read? What do you think about this? And what do you think about that? And we go through. And then the final stage is memorialization. And that is where you have a drafted contract. Remember, the only thing that is not confidential is if it's something I'm required or permitted to report. That's like a criminal action or a safety issue I need to report. Or if you reach an agreement. So if you reach an agreement, that becomes public law, especially in Florida. Florida has the most liberal public records laws in the world, bar none. And so that contract Anybody can look at it, anybody can see it once it hits the court system. And that is not confidential. And so that is definitely something to also keep in mind. But like I said, sometimes things will happen where I don't want to use all six. For instance, let's say I see this mostly in landlord-tenant cases and family law disputes. If there is an issue of domestic violence or high conflict to where the parties just cannot be in the room with each other for any reason whatsoever, then I may actually start the whole thing with the parties in different caucuses. And so I will go in doing a opening statement and ask the party, say, what would you like for me to convey to the other side? And then I'll go back and forth between the parties, and they may never see each other the whole mediation. And that is because you don't want to re-victimize people, and you don't want to have conflict derail your mediation. So that's something to consider when doing this, is that a mediation can look a number of ways, and just because your mediation goes one way doesn't mean that if you go into another mediation it's going to look the same way. Even if you did a mediation with the same mediator, more than likely it's not going to look the same, because everything is a case by case, moment by moment decision being made. So what if I don't want to mediate? I get this asked me, not a lot, but a good amount. It's kind of like, who are you? Why do you think you have authority to tell me I have to come someplace? Why is some judge requiring this? Whatever. And some people, they take exception to the fact that they've got to go to some type of meeting instead of being in front of a judge. They want their day in court. Okay. That's fine. Well, most judges, now I'm saying generally speaking, most judges for certain types of cases in certain jurisdictions, I'm going to heavily quantify this, they may have already established a rule that XYZ types of cases have to go to mediation. Why is that? Well, think about it. And depending upon where you live, there may be one judge for every 500 cases. And there may be 50 mediators for every judge. Okay. So if a judge can get cases diverted to a mediator, and a mediator can resolve 80% of the cases, that takes a significant burden off of the judges. And so judges will do typically whatever they can do to lighten the burden in a way that resolves the conflict faster and more expedient than if it goes the traditional route. And so that actually means the parties are usually more satisfied than if they get to the judge. And so it's not just the judges saying, I don't want to do my work. They do. They work extremely hard, but they realize there's tremendous benefit to this. And so most of the time they will require the parties to go to mediations for certain cases. So what happens? Well, you're required to sit through, generally speaking, my introductory comments and the opening comments by the parties. After that, if you decide that you do not want to participate anymore, you can ask what's called an impasse. Impasse is an old legal phrase meaning no agreement. So that means that you can walk away and I can't force you to stay. Now, I've had several cases where somebody called for an impasse and then they continue negotiating. And I don't tell them I'm stopping because they're reaching an agreement. And I've had cases where somebody would say, I'm on impasse, but they never did follow through with it. And I didn't force the issue and it got settled and everybody walked away happy. I could say, okay, and walk away myself, but that's not helping the clients. And if they're going to be happy or possibly happy, who am I to take that away from them? You know, I'm not supposed to be making any decision. All I'm supposed to be doing is helping. So it's not helping if I walk away. And that's my rationale behind it. Other mediators may see differently. So, you know, some people, they might get a shock after dealing with me and they go to mediation and they get somebody that might be older or younger, or, you know, they don't care or they're tired or had a bad day. And they say, all right, I want impasse. And then the mediator, you know, turns off the meeting. That might blow their case out of the water. They weren't expecting that. But technically speaking, once you ask for an impasse and you've sat through the opening discussions and you've sat through the, you got the opening statement from the mediator and the opening comments from the two parties. Once you sat through that, you've been to a mediation. The judge will typically not say anything else because it came to an impasse. In cases like Florida, all the judge can do is say, what happened? I can say it impassed. Now, might be, why? I can't tell you that, Your Honor. What was said? I can't tell you that, Your Honor. I can't say any of that, but I could say it reached an impasse because I have to notify the courts. So that's the same thing as a memorialized agreement. It comes under that same law. But other than that, nothing else. So in most cases, the judges won't say anything. You've done what you're supposed to do. Everything's fine. And that's how you get out of it. But I don't recommend it. I really don't. Trust in the process. Most of these mediations, they're only supposed to be 2 to 3 hours. Have faith in the process. It's really worth trying. I think you would like it once you've given yourself over to trusting it. I can come up with some very crafty ways of handling problems when I have parties willing to work with each other. It's only when you don't want to work with each other that I'm limited in my abilities. So why should you mediate? You remember me talking about that people want their day in court? Well, guess what? A lot of times I'm as close as you're going to get to your day in court. In fact, most of the time, if you see me, that means this is going to get settled. I'm not calling that a success or a failure. I'm just saying that based off of my figures and stats, generally speaking, if you come to me, we're going to probably reach an agreement. And so it is your chance to have a say. You know, you think about all the depositions, all the stuff that happens. You really don't get a chance to say, this is how I feel. This is what happened to me. This is what I incurred. You don't get that. Mediation, I give you that chance. Now, you may be just telling me. You may not be telling the other party because maybe the mediator says, it may not be that important. Or maybe The mediator does, and you are able to. I can't say how that's going to play out because every mediation is on its own. But you do get a voice, and it's an active voice. So what does an active voice mean? Well, you're the one that has to say, I'm going to go with this agreement or not. So if let's use the policyholder example. You're the policyholder. You are saying to the insurance company, I'm willing to go $7,000 down off my ass to $97,000. And then whenever they come up with the $75,000 final that they're saying is their best and final, you have to sit there and think about it. You have to talk with your counsel if you have counsel. Some people don't. Some people do it all on their own. And so you have to sit and say, okay, I think I'll be better by doing this than going traditional route. And so I'm going to take the $75,000. But you also have the right to say no. You're not forced. And that's the beauty of it. You get to make your own decision. And that is something that you don't often see in the court system. Another issue that why you should mediate. You're dealing with a professional that, like a judge's job is not only to referee, but to make sure that the law is being adhered to. My job is to help parties get past conflict to reach agreement. I don't care what the laws are about something. I care more about what the agreement is that you're willing to reach. I don't care what is equitable. I care more about what you think is fair. So in that case, think of the story of the citrus orchard. There were 3 siblings that they inherited a citrus orchard. If they went to court, the judge would have ordered some type of judgment that said a percentage of share of the company or a buyout of interest or something along that lines. Because it's just an asset and there's a requirement by statutes as to what the equitable distribution of the asset should be in a probate case. But in a mediation, I can look at the interests of the siblings. So maybe one sibling is not interested in the fruits. Okay? They want only the seed and the shoots, because they want to start a nursery. All right? So then you got to know one that they're only interested in the juice. Okay? They just want the juice. And then you have because they're wanting to run a true citrus orchard. And then you got to know one that they want the peels, because they're going to take those peels and they're going to sell it as a food additive. All right. And so they're going in that realm, and they want their own business, but they want those peels. You got to know one that they're interested in trees and the juice, and the other one just wants some shoots on occasion and seeds, because they're wanting to do a nursery and do that kind of thing. A judge would never look at that, usually. Now, again, every judge is not the same, so please understand that, but typically they won't. A mediator, yeah, we could come to all sorts of agreements that would be very creative. Okay, all peels are going to be from, going to this party, and they'll buy it from the orchard for X amount of dollars, and they have right of first refusal, and all juice will be kept to this party, And the juicing process and the tree trimming process will not harm any of the seeds or any of the shoots, and they will be sold to the other party with right of first refusal. And we can put all the stuff in there. So it's really good that you can be creative, because the whole idea behind it is that there is a win-win somewhere. And provided that you have enough time, you have enough skill, and you have enough willingness among the parties, it is possible to come to a win-win. And so we always, as mediators, try to look for the creative solution. Another reason why people may want to use mediation is that it's a savings. Think about the number of months or years it can take to go to court. How much money are you going to have tied up in counsel, going to all the different trials that have nothing to do with the final verdict, but we're going to have a case to throw out this part, or we're going to have a case to accept this. All these different case trials that you have to go to and meet and be there is taking time out of your day. It's taking money out of your pocket in the hopes that you finally get a settlement in your favor. And in some states, if that settlement, either the judgment or the settlement agreement pre-trial, if it's not a certain percentage of the ask, you have to bear all that cost yourself for all that the other side doesn't. So there's all this stuff on the back end nobody ever really knows about until you have a lawyer explain it all to you. So this can be a very cost-saving, time-saving mechanism. And so you may want to do mediation, because in a matter of days or weeks, at the most months, you can be in front of somebody like me across the way from the opposing party, working, trying to reach an agreement that you both can sign off on. And so long as you keep your emotions in check and you kind of commit to the process, a lot of times, I'm not saying always, but definitely a lot of times, you'll come out better than if you ever went to court. So I highly recommend it. Another reason that you may want to do mediation. Studies have shown over and over that when a party works towards an agreement and they help craft the agreement, they're more than likely going to follow through with it. How many times do you think it happens that a judge makes an order, does a ruling, and there's a judgment on public record, and the other side just doesn't follow through? I remember when I was working in the clerk's office, and somebody come to me and they say, "But I've got a certified judgment." Congratulations, you got a piece of paper. Good for you. And you would see that judgment languish away. Some of them over 21 years. Nothing ever done. Party never paid the money that they was ordered to. And the process is so onerous to collect on them that nobody followed through. But surprisingly, with mediations, that's not the case. When somebody is actually sitting across the room saying, "Look, I will do this if you will do that, and I will do this if you will do that," almost 80% of the time, they're going to follow through with it, which is a far sight better than what you might see if you have a judge render a verdict. So that's something to consider. So what's it like to be a mediator? people come to me and they ask me this in hopes I'll just spill the beans and I'll talk about some case I'm not supposed to talk about, because everybody wants to hear about conflict. They love the drama. I absolutely hate drama, which is crazy that I work in a field where there's always drama. When I wake up and get ready for a mediation, my problems are my own. When I go into a mediation, my problems still are my own. And when I leave that mediation, my problems are still my own. But what about their problems? That's their problems. Mediation is the only field that I know of where there is no winning. Now, what I mean by that, I don't keep a tally sheet. Now, other organizations, they do keep a tally sheet, but there's no such thing as a win in the world of mediation. If you want to impasse, or if there's no agreement, okay, no agreement. If you want to reach an agreement, fine, reach an agreement. There is no winning or losing in my world. As long as I do my job competently, it is what it is. It's the parties' conflict. They get to decide what they want. And I can only go so far as the parties allow me to go. So in that case, I can't be held accountable for the outcome because I'm not in control of the outcome. I will say that mediation is a great study into the human condition and the human psyche. I often do not see people at their best. I see people that are hurt. I see people that are troubled. I see people that are stressed. And it lets me know that we all have issues. We all have problems. I think the most interesting part about it is the invigoration that I get. When the parties truly trust the process, and when the parties really do try to work together, I get a high. I do. It's like a runner's high or anything else. It is because those agreements, they're inspired. There's something there that's greater than any of us touching that document. I don't mean to put any type of religious or spiritual connotations on something, but I've drafted some contracts that I never would have contemplated being fathomable. And the parties responded back to me later after mediation going, I never thought about this as being an option, but yet they work together. And I think that's something about the human condition, that if we would see each other as people, not our status, not our relationship, but as people, and that everybody has an inherent nobility and dignity to them, and you honor that, and you respect that, and you treat them with compassion and respect, and you treat the parties in an equitable manner, I think our society would be far greater than what it is today. And it gives me hope in what mankind could do if we'd ever get our act together. There is a nobility to mediation. The constant hope that there is a win-win solution. There is a better option out there. Admittedly, some of my financial cases are probably the most soul-sucking cases I deal with. I might spend 15 minutes negotiating a deal. We're talking massive amounts of money, but there's nothing to it. It's just a negotiation. And then I might spend an hour on an eviction case, and I'm just as happy as I can be because I've had to pull out all my little tricks, all my little different methods I have in my toolbox as a mediator. In the end, it doesn't matter one way or the other. The financial mediation is just as valid as the eviction mediation. They have no bearing on each other. Nothing is, so I can't hold them the same, although I do appreciate the mediations where I do have to work a little bit because I am professional and I do like to stay in practice. If I only did negotiations that lasted 15 minutes, I think it'd be like a runner that only runs for 15 minutes rather than a runner that constantly is running and changing their routine so that they can keep their muscles in shape. I think that any profession needs challenges. And if you asked a doctor or lawyer or any other professional, I think that they would say that they love a challenge. That they want some moderate challenge cases to come along just so that they stay in shape. But all in all, every case is the same to them. That's the way I am as a mediator. Every case is the same. There's some that I like better. There's some that I absolutely loathe. Anything with a pet and anything with children, I can't stand. And it's in that order because most Americans see animals more valuable than children. And people use pets and people or children as pawns in a negotiation process or as leverage. And also logic. People are so emotionally tied to children and so emotionally tied to pets and animals that sometimes is hard to get people to think logically. And so in those cases, I do kind of have a sinking feeling every time a child's involved or a pet's involved. They're not my favorite cases, but I do them because that's my job. As a mediator, I'm trained by the state of Florida and certified by the state of Florida to handle county, circuit, and family disputes. So basically, any monetary amount case I can handle. You're going through a divorce, or somebody's baby daddy, and they're filing paternity case against you. You might see me do the Hawaii eviction mediations. So you're getting evicted. You might see this old country Florida boy, and I'll try to work through your issues. I also do USDA mediations. And so it could be anything from a crop loss to wetlands mitigation to first-time home buyer. You name it, anything that USDA covers under their law, guess what? I can handle it. And it's very rewarding work. What are issues in the mediation field as I see them? Right now, mediation is highly regulated, and that can be a very good thing. Problem is the regulations are not the same across the board. So in one case, I may be able to force the parties to attend a mediation if they don't want to agree on a date or time or they're unresponsive. So if they refuse to go along with the mediation and having it scheduled, I can set a mediation date and time, notify the mediation center or the agency that's hired me out, and that's that. Other centers, other agencies, not the case. So that's a problem. A judge orders that you got to go to mediation, but yet you don't want to set up a date. I can't force a date and time on anybody because that center won't let me. So how are we going to get this resolved? It makes my job needlessly more complicated. Another issue is good faith. So what is good faith? Good question. I've asked numerous attorneys and lawyers. They've always asked or answered the same way. Good question. In the state of Florida, the Supreme Court of Florida does not require good faith. USDA, Department of Financial Services, requires good faith, but they don't state what good faith is or what the mediator can or cannot do if he thinks that somebody is not operating in good faith. This nebulousness needs to go away. And it's funny because even with USDA, there's been federal court cases where judges have ruled there is no such thing as good faith in the court system. And yet they require good faith in their mediation system. But even though they require it, there's no teeth to it. I can't just say, all right, we're you didn't attend the mediation because you didn't operate in good faith. There's not that. There are rules to mediation, and those rules change constantly, and you need to know it. Because like when I do my insurance cases, Department of Financial Services requires the insurance to have the ability to mediate up to the amount that is being claimed. So let's say that going back to that insurance mediation example, I asked for $97,000. I had $100,000 claim. They come, they say, we only have authority to $50,000. If it's a Department of Financial Services mediation, I can terminate that mediation if they do not have authority up to $100,000. Or 97 if the party is saying we're not going to ask for the full 100, just 97. The insurance company has to have $97,000 worth of authorization. Otherwise, they didn't attend. These laws and practices are so nebulous, it's hard for even mediators to navigate. And when you're not in this field, it's even harder for a consumer. I think that there needs to be some sort of standardization. Another issue with mediation is how it's done as far as payment. The payment is interesting. I've got a article that I'll put down below in the link that talks about the aluminum age of mediations and why I call it that. Some of these laws have not been updated in over 20 years. And so mediation as a profession has suffered financially over the years. I think that we need to, again, change the laws to make the payment more equitable and more transparent, because in some cases the government pays for the mediations and you pay nothing. Other cases, one party will pay over the other, and in another case you might have it where the parties split it some way, and that can be confusing if you don't know what you're actually paying and what you're liable to pay. And if that payment isn't conducive enough for a mediator to feed their families, you're going to get questionable results. And I think that needs to be handled. All in all, I think there needs to be more of a revising of the rules and policies. I think everything needs to get to a standard, and we need to go back to, with that zeal that we had in the 1980s and 1990s of codifying things in law. I think we need to have that same zeal to edit and modify. This is a field that's not been heavily modified or changed in so long that there's a lot of issues that have crept up because of lack of activity. We need to have some type of active voice, and the problem is that right now we have so many mediators that they're either doing it only part-time, or there's no like unified organization of mediators looking out for our benefits and our well-being. And so therefore we're not actually engaged and active and have an active voice and unified on this. I think that needs to change. Well, I hope you've enjoyed this video. I hope I've explained mediation. Hopefully it wasn't too boring. There's a lot of technical jargon. If you have any questions about mediation, please put it in the comments down below. I'd love to hear those questions. I'll address them as best I can. If you've ever been a part of mediation, I would love to hear that. Go ahead and, like I said, any comments down below, questions, I'll definitely field those. And with that, if you hadn't already subscribed, that would help this channel out greatly. If you like this video, give it a thumbs up, and I'll see you again next.